Hey fam, welcome to another episode of Good, Bad, and Ugly about real estate. I have a great guest for you today, a new friend of mine. His name is Rob Keating. Yeah.
Thank you.
Hey
Appreciate being on
Rob,
the
how
show
you doing, bud?
today.
How's everything going?
It's going well. It's going well. Great to talk to you today.
Yeah. Thank you for making time for us.
Yeah.
So, audience, everybody, we're used to having other investors come onto the channel, and I have a great gift for you today. Rob is a real estate lawyer, and I am going to pick his brain, and I have him share some of the things that you probably would want to know. And then toward the end of this, as always, give you the ways you can reach out to him if you want to utilize his services. So if we always start, Rob, by just kind of introducing ourselves. So can you introduce yourself to the audience and how you got into real estate law?
Yeah, you bet. And thanks again for having me on, Jose. Yeah, so my name is Rob Keating. I've been practicing almost 20 years. It's hard to believe I'm that old to have been doing something this long. But yeah, I've been a transactional attorney my entire career, which means we handle real estate and business transactions and assist investors and companies get financed and get projects off the ground and get deals done. And so, been working on real estate transactions my entire career. And, my focus is really on the investor management, the deal structuring, that type of thing. I've got an amazing title team that assists with title reviews and easements and those types of things. So I'm the guy trying to get deals done, and my that's where my area of expertise sort of lands.
Gotcha. So just right off the bat, because I heard you mention it in your intro, so I have this question for you. Do you guys assist or help structure business acquisitions?
Yeah, you bet. M&A transactions for sure. That's a very core competency of what we do.
Awesome. Okay. So I'm making a mental note because I could probably definitely send some people your way, if anything, just to answer some questions, but hopefully they're
You
in
bet.
markets that you are in. So let me just start with that.
Yep. Yeah.
Um, what areas, what states, I should say, are you able to directly assist people in with your team?
Yeah, so I'm licensed in the states of Colorado and Washington, and my partners are registered attorneys in North Carolina, as Arizona as well. And if you've got some type of connection to those states, Colorado, Washington, Arizona, North Carolina, we can absolutely assist. And there's, we don't like filing lawsuits ever, of course, and so. Um, there's practicing law and entering appearances with respect to litigation is a lot more formal. But if you've got some type of toehold in one of those states, we can certainly assist. And I'm hopeful that a lot of this advice sort of transcends legal borders. It's more like a holistic approach of how investors can sort of protect themselves with respect to their investments in their real estate acquisitions and transactions. But those are the four states in which we're primarily operating.
Sweet. So the reason why I reached out to you, and like I said, I'll go in a little bit more deeper. That's more broad for people, but as a private money lender, person that's trying to help people get into deals, the first question I have for you is, what are some of the common documents that a private money lender should make sure that they have, like you said, regardless of what state they're in, to ensure that they're mitigating the risk of lending money to somebody who they may not have a business relationship with.
Yeah, you bet. Great question. Something that I see a lot. And, really what you're looking for as a private money lender is um, first off, a promissory note that outlines the amount of principal that's being lent and borrowed, the name, some certain identifying information. But those promissory notes are usually a couple pagers. They're not super detailed because the details are that, lender X is loaning a certain amount of funds to borrower Y. There's an interest rate specified. There's a term. There's a repayment period, and so the promissory note sort of is sort of the fundamental document that you want to see. From there, you definitely want to see a personal guarantee. And whether you're lending to a person, and sometimes a promissory note will serve as a personal guarantee, because if the borrower is a person, then they're sort of automatically guaranteeing the loan. If the lender is an LLC, you definitely want to get a personal guarantee, because those LLCs, as we know, Jose, and they can be empty shells, right?
Yep.
People set up one LLC per transaction, so there may not be a lot to dig your teeth into from an asset standpoint should there be a delinquency or default in the loan. So then, and then beyond that, you really want to have some type of security in the underlying property. So if you're loaning money for renovations or for to close a gap on a deal or whatever it may be, you really want to basically have a mortgage, deed of trust. Every state's got sometimes different language and instruments that they use, but that deed of trust is securing your debt with that collateral. And there's a specific way that you attach collateral to loans, and so you got to sort of use some magic language and jump through some hoops. But typically, the way you secure real estate as collateral is by filing a mortgage or deed of trust document in the county in which the property sits, and then those three documents, the promissory note with the personal guarantee with the additional collateral from the real estate, that puts the private money lender in much better stead, and outlines exactly what your recourse is. And if for some reason there is a default or delinquency, you can always uh, go against a borrower personally through the personal guarantee,
Sure.
or with respect to foreclosure on the property.
Gotcha. And would you recommend to a client to get like lender's insurance on that as well?
Yeah, sure. And we don't do a ton of that. There's title policies
Yeah.
that include the lender, and so if you're doing like a acquisitive transaction where a title policy is going to be issued, a lender's policy makes some sense, because if there's a title issue, like if you're lending $400,000 and the property is worth $500,000, well, if there's a title issue that substantially um, reduces the value of that property because of that title issue, you can also be, as the lender, one of the insureds, and potentially get a payout of a claim, because instead of the property thinking, believing the property was worth 500, it's now only worth 350,000, and that changes things from a risk exposure perspective. So lawyers love insurance, Jose. We're always going to say yes when the question is more insurance.
Sure. So, most of the people that I work with, sometimes they'll structure a deal where they're strictly just a private money lender, but sometimes they'll kind of partner with the investor where they're getting paid for on the money that they're borrowing, but they'll take a lower interest rate
Mhm.
for interest or equity
Yeah.
into the deal. In that situation, would you recommend a LLC structure between the two, or would you prefer like a JV agreement, or what would you advise a client to do?
Another good question. And it's sort of six to one, half dozen to the other. I think that you have there's sort of pros and cons to getting into an LLC with somebody, and it's hard to unring that bell. It's hard to unwind that sometimes, which
Right.
is good and bad. Definitely, at the very least, a joint venture agreement outlining the terms that everybody is expected to play ball under. And so we've seen some really sort of back of the napkin JV agreements that I can't even really tell what the agreement was.
Yeah,
Somebody's lent some money, and somebody's going to pay back some money, and there might be an extra kicker or spiff or whatever it might be, but it's the contracts can be so vague as to be unenforceable. And so whatever the deal structure takes, having a very well thought out and professionally drafted agreement outlining the payouts, distributions, terms, rights, privileges of each party makes a lot of sense. I do think that there is value in structuring a transaction like that through an LLC. But if somebody's unscrupulous on the other side, sometimes a private money lender isn't lending the entire amount of the property, and so
right.
they may so they may not have majority control or something like that. So it's like if you do get into an LLC, you want to be really thoughtful about it, because if the other person is quote unquote managing the property, they could file a tax return that's fraudulent, or they could do something that all of a sudden really blows back on you, and can end up being, sort of out of the frying pan into the fryer, so to speak, or if I'm using my cliches right.
Nope, that's
Uh,
pretty good.
but yeah, but nonetheless, JV agreement also works really well because it's just enough of a lockdown contract to make sure everybody knows what they're doing without getting too far down the aisle with somebody and really being in a business relationship with somebody you may not know very well.
Awesome. All right, so I'm gonna get to the more newbie type questions, right? To kind of
Sure.
help them out.
Um,
So,
yeah.
what are the most common legal mistakes new real estate investors make?
Yeah, I think it is, not knowing what you don't know and or trusting people on the other side. And so, the thing that I see, and it's also another cliche. I speak in cliches here, and so I'll try and expound upon it. But an ounce of prevention is worth a pound of cure. And I see so many real estate investors that come to me after they've had a problem with a transaction, as opposed to coming to me when they're structuring it. And once you've got a problem with a borrower and you've got a delinquency or a default or all of the above, the borrower starts to go dark and it's really hard to get traction with them. But at the outset of a deal, everybody's very positive and very optimistic, and they'll sign just about anything to get the money, right? And so
Right.
we really yeah, we really like to be in at the forefront of the deal so that we can structure it in the ways we talked about with respect to the personal guarantee and collateralizing the underlying property and stuff like that. And so I think a lot of like new investors, they they just don't take the steps necessary and or have the conversations with the professionals to really button up the project. And oftentimes the projects are done with friends, family, business networks, brokers they've used before, stuff like that.
Right.
And none of those people are necessarily attorneys, and while lots of those deals can go great, they can go south pretty quickly. So I would say, putting your trust in the wrong people and not having a a transaction sort of professionally structured and or getting the protection you need at the very outset is really the issues that I see most commonly.
Okay. How should an investor structure their first deal from a legal standpoint?
Good question. I mean, every deal is different, which makes my job, fun and maddening too, right? But the three things that we talked about, that promissory note, the guarantee, the deed of trust or mortgage, recorded mortgage agreement,
Sure.
and then probably a joint venture agreement, depending on what the transaction is, if there's other things going on besides just the borrower creditor relationship.
Right.
Um, so,
But if we're
you
talking
know,
about, let's say an investor is partnering with another investor to do like a fix and flip.
yeah. And in that case, I think that setting up an LLC makes some sense. Outlining, and whether it's a JV or not, the terms remain the same. Investor A is going to give X amount of dollars. Investor B is going to give Y amount of dollars. They're going to pool their resources. They're going to hire a contractor. You need to fit, and they need to typically mutually approve. With a two-person partnership, there can be a deadlock pretty easily, so you want to make sure that you're also taking a look at the deadlock provisions. But in a situation like that, you want to mutually approve the contractor, you want to mutually approve the budget, you want to mutually approve the various aspects of the transaction that can get you in hot water. And so probably again pretty similar to that tried and true like joint venture LLC overlay plus the debt financing or the debt documentation to make sure that's buttoned up. Um, but in a situation like that, an LLC could make a lot of sense. But at the very least, a joint venture is saying what everybody's putting in, what everybody's going to get out, additional duties. If one partner's handling the contracting or working with a contractor and the other one's doing the numbers or something like that, that's
Right.
specified and outlined as to who's doing what and when, so that the expectations are set at the beginning, and you just have less, because mismanaged expectations are what oftentimes caused the biggest heartache, where one partner was thinking the other partner was going to do this, that, or the other thing,
Right.
and the other partner was thinking the same thing, and then all of a sudden they're looking at each other going like, well, who is supposed to do what here?
Yeah. I just help somebody ask a whole bunch of questions like that, and they're like, "Oh, well, we didn't think about that."
Right,
Because
for sure.
the hard question is, so what happens if that person gets hit by a bus, and so who's responsible then? Like, are you still going to pay like that person's family or that entity?
Yeah.
Like, dang, that's dark. It's like it's dark, but these are questions you have to ask because you want to know what the answers are before they happen.
Well said. Yeah, we talk about the four Ds: death, disability, divorce, and dissolution. And and that's why an operating agreement from an LLC can be really valuable, because those things are typically already set forth in there. And so you can go through the the sort of tried and true formula of an operating agreement, and it has a succession plan sort of built in, and obviously it's super customized. But you're absolutely right. And as attorneys, we hope for the best and plan for the worst. And you hate to see somebody have that situation, but it's also, one of the four D's is permanent disability. Like, what if one of them gets hit by a bus but lives, but they're not able to perform the services that you thought they were, or that the other investor thought they were going to perform? So there needs to be a sort of some type of like coordinated buyout, or because you're going to have to hire somebody or find another partner to perform those services. So that's also a very important aspect as well. And again, it doesn't happen all the time, but when it does, it causes a lot of pain and strife and uncertainty, and those things lead to lawsuits, which is the worst case scenario, because they're so inefficient, so expensive, and so cumbersome to pursue for anybody.
Appreciate that. So, a lot of people they hire a mentor and a lot of them always say start some type of LLC structure. I'm not sure if this is your lane or not, but when would you advise a client to go from an LLC to an S corp?
And so, with respect to the holding of property, the LLC tax as a partnership is really what you're looking for, because real property, historically appreciates. And so what happens is and there's so many reasons why you would retitle and pull that property in and out of that LLC by filing a deed and saying, okay, on day one, Rob owns the property. On day two, because of our arrangement with each other, I'm going to transfer that property over to the LLC, so that the LLC, which you and I now own in this example, owns the property. And then later, I decide to buy you out, let's say, or you decide to buy me out, and we want to transfer that property out of that LLC back to one of our personal names, or over to a new entity that we own solely, that doesn't have the two of us sort of muddying the water, so to speak. Well, each one of those transactions can be taxable, especially where you're pulling it out. And so if we use an LLC for that, those transactions in and out of the LLC, even if the property is appreciated over that period of time, are tax free. But if we put that same property into an entity taxed as an S corporation, let's say for ease of arithmetic, it's worth $1 million on day one, and then 2 years later we want to move it out for whatever reason, it's worth 2 million. Well, the basis is $1 million. The new value is 2 million. Uncle Sam, if you have the wrong structure in place, wants to tax that realization event, that $1 million of gain, even though there hasn't been an actual sale. So with holding property, you really want to maintain an LLC tax as a partnership, so you have that continued flexibility. S corps are more for operating businesses, so like the property manager for that property or others, that could be a very viable thing to structure as an S corp. And so we talk about like holding companies, and especially real estate holding companies. We really want those to be an LLC taxed as a partnership, but the operating agreement, the operating entities should be LLCs taxed as S corps, or standard S corps, so that you don't have that problem of the realization event, the taxation event occurring just because you're trying to restructure something.
Awesome. So there's a lot of different philosophies on this, but what are the legal advantages of using a land trust in real estate investing?
Yeah, the trust can make a lot of sense, and whether there's different types of trust, but a land trust is typically like a revocable inter vivos trust, which is to say that you can cancel it moving forward. You can, and it's inter vivos means something you set up during your life, as opposed to testamentary trust, which you would set up at your will upon your death. And so you've got these trusts that make that manage a few things for you, including probate, which is to say the trust would say, Jose owns the property on day one, and he's going to transfer it over to the trust, and we would prepare a deed from Jose to the trust, and then that trust agreement would say, well, during Jose's life, he gets to manage the property however he sees fit. But upon his passing, his interest in the trust goes to, and therefore the property goes to your heirs, your kids, your wife, whoever it may be. And so it avoids probate, which is nice. In some states, probate is a four-letter word. In Colorado and Washington, it's not the same type of thing because there's simplified probate, and you can make the moves you want to starting very quickly. But in California and New York, where I don't do probate, but I've heard horror stories about how long it takes. So the trust can be a really nice vehicle to do those things. But what a trust doesn't give you is limited liability protection. So what we have sort of transition to is using an LLC in place of a trust, because we can do the same things in an LLC. We can say, to your great point earlier about what happens if one of you gets hit by a bus. Well, we can say in the LLC agreement, upon, in the case that we have a LLC tax as a partnership, Jose, upon Rob's death, his 50% interest goes to his wife, or his 50% interest goes to his kiddos to be managed in trust while they're young, or what have you. So and then you also have limited liability protection. So if there's a slip and fall of the property, it's not, the maximum exposure you have is that property. Whereas what we'll do with trusts is we'll set up the trust, and then we'll set up an LLC, and the LLC will be owned by the trust. So it's not as valuable as it used to be necessarily, because we can accomplish basically all those goals through an LLC. People typically call them family LLCs, which is just like really nomenclature and semantics, because a family LLC is just your typical LLC with some provisions in the operating agreement that allow it to transfer upon death to your heirs outside of probate.
Oh, I love it. That's good information.
Thank you. Trying.
Um, so, a lot of people, they sign contracts, don't read them. Just they, like you said, they're trying to get through the transaction. They want to get their first deal. They want to, um, make some money like now instead of later. What are some key clauses that investors should never overlook when entering into a purchase sales agreement?
Yeah, and when investors come on to a deal, it's usually they would typically sign like a subscription agreement. Like depending on like the transaction, like what we'll do is we'll set up like sort of these syndicated deals where a promoter says, okay, I need $1 million to go buy this piece of property, and then I need $1 million more to scrape it and put in a fourplex where a single family home used to be. And so what we'll do there is we'll use the securities laws to protect the promoter, and then there's usually a disclosure document, or should be, that outlines the risks, what we call a private placement memorandum. It's like basically a mini prospectus. And then what happens is, in this example, is those investors, they accede to the company by signing the operating agreement. And then, so let's use that as an example of the question you asked. And so those investors in those types of deals are looking at are a few things. First off, the capital call. And when an investor puts in, let's say, 200 grand into a project like that, 10% of the amount you're looking for,
Mhm.
that's typically all they want to sign up for, right? Like, if the promoter wants to go back to the well and raise more money, then typically that investor should have the say in whether they want to play ball with that additional raise. But there's it's usually pretty early in an operating agreement, but those capital contributions, the managers or promoters can force those, what we call a capital call. So it's like, if they go over budget or they screw something up or, for whatever reason they need more money, if that capital call isn't limited, then all of a sudden your 200 grand could become 400 grand or whatever. And, you never want to be um, called in that respect because you typically want to have the control over the amount of investment you're making. So the capital call provision, capital contribution provision is really important and what kind of safeguards are on there. And then you also want to look at the distribution. So there's the contribution side and then there's the distribution side. And depending on how much weight you can throw around, which typically, involves money and percentages. If you're bringing in 50% of the transaction, in that example, if you're bringing $1 million to a $2 million raise, you've got some ability to control certain things. And so the distributions, for instance, you want to see if there's like a waterfall in your favor, and that waterfall says, would specify, for instance, in this example, like a priority return that says, I as the big time Act Daddy investor, I want my distributions paid first, for instance, right? And
Right.
once my $1 million is paid back plus a 10% annual return, then we can start splitting it up with everybody else or whatever. So the contribution side and the distribution side, I think is really important, and understanding when you're going to get paid back and how. Another really important provision is management, how you approve and remove and elect managers, because that is really challenging insofar as the management is key, right? If they're doing something that nobody likes, then you got to figure out how to remove them and get them off the ball, and that can be a real challenge. Some other provisions that are really important are I had one in mind that just sort of slipped my mind, Jose, but the management. Amendment of the operating agreement, and you want to make sure that amending the operating agreement is really difficult to do because you sign up for one type of arrangement, one type of deal, and if the managers can, or a certain amount of controlling investors can change that operating agreement, it really, you start chasing your tail where it's like, oh, I thought I could remove the managers like this, but it's actually now I've got to jump through all these hoops, and it's way more difficult to to remove the managers because they amended the operating agreement to protect themselves. So those are sort of four key: capital contribution, distributions, amendment of the operating agreement, and management structure, and how that can be amended. I think are four really great places to start. And whether that's in a JV agreement or an operating agreement, very important to know those fundamental aspects there.
Appreciate that. Hey, in the interest of time, I just have one question before I let you go, and that is, a lot of the people that I work with, some people are getting into what they call lending, but they're using other people's money, right? So
Yeah,
let's say, for example, you and I are into an agreement where you have the deal and I say I have the money, but it's not my money. It's, Uncle Joe right behind me who's going to lend it to me so that I can get into this deal. How would
yeah.
you advise people to structure that type of scenario where the end lender or the initial or the real person lending the money is covered, but the other person that is basically using other person's money is also able to stay in the deal and make a little bit of money as well? What's the best way to start structure that?
Yeah, yeah, great question. And the first answer is very carefully, and then
Of course.
my, my, my next question is who would I represent in that transaction? Because if I represent Uncle Joe,
Yeah.
right? I want to have a lot of protection all the way through, basically the same as, let's say, you, Jose, if you're the person using other people's money in this example.
Right.
Um, and so, probably if I'm representing Uncle Joe, I want a joint venture agreement with you. And then we want to be able to see all the documentation all the way through with respect to um, how it's going to be repaid and what have you. And Uncle Joe probably wants a note directly with you, Jose, in this case, plus the JV agreement where you're on the hook to repay him, and he may be as a third party beneficiary able to sue the borrower or able to foreclose on the collateral himself. If I represented you, we would want to really be really careful about having you sign up any debt obligations yourself, and we want to sort of pass that all down the line to the end borrower. And so, it's a matter of perspective, but again, the same things will apply to all those transactions, which is professionally drafted agreements, structured really well from the outset, making sure Jose and Uncle Joe are protected in their own ways. But if I represent Uncle Joe, like, I want a personal guarantee from you, and then I also want a personal guarantee from the borrower, and I want secured collateral all the way through, and just make sure that everybody's in really great shape to repay Uncle Joe if something goes wrong with the borrower. So, but lots of details to sort out there, and that's the type of stuff where, um, again, being at the early stages of that deal is so much better than being late, because we can really protect Uncle Joe in a way that he's probably not realizing, because he's leaning on other people, and Uncle Joe may not be a real estate professional and just wants to turn, 50 grand or 150 grand into, a few more bucks. But then, it's one thing um, to not make a great return on that investment, and it's quite another to lose the entire principal, right? So, that's definitely what I'm thinking in that regard.
Awesome. Just so you know, I got 2 minutes, so I'm gonna try to get this in. So
Yeah,
I want to ask you, and I'm gonna cut this part out. Sub two, and then how can people reach out to you to utilize
totally.
your service? So,
And happy to do another podcast with you, Jose, where we have some more time, and really appreciate being on here. Again, my name is Rob Keating. You can reach me at 303-448-8801. Happy just to spitball a transaction with you. And my website is keatingandlyden.com, KEATINGANDLYDEN.com, and you can also find us there. With respect to subject two, really neat sort of avant-garde transactions, because we just came out of a low interest rate environment, and now we're at a very high interest rate environment. And so we hadn't seen them for a really long time, but you're seeing them now, and that means you're selling the property subject to the existing mortgage, and the existing mortgage is going to be quite a bit lower interest rate than you can get in the current environment. And so there's definitely risk on both sides of that transaction, but they're doable, and in Colorado they're lawful, and they can be a really cool tool to keeping costs low. But as long as that lender keeps getting paid, the lenders don't typically call the notes due, but they can if they see any squirreliness there. So in summation, definitely something to discuss, maybe a longer discussion, because they can be complex, and there's risks
sure.
on both sides of the transaction, but very, very doable if done right.
Appreciate it. Well, audience, that's all the time we have. So I appreciate you all. Rob, again, thank you for giving me your time today. All these nuggets. And I'm definitely going to be calling you after this, because I have a deal that I'm going to use you for. Uh, and
Nice. Thank you.
yeah, it's
Yeah, again, would love to be back on the show, and let me know if there's additional questions that come up after this interview or what have you.